and welcome to Narayana IAS live session. Students, in today's live session, we are going to discuss a very important topic, and this topic I think or I feel that can be asked in the UPSC examination this year. Why and what is the name of the topic? The name of the topic is Supreme Court to look at immunity to governors under Article 361. Given that we have been hearing the governors misusing the powers given to them and the immunity they have, in this context, understanding the topic, that is immunity to governors under Article 361, is very important. So this was a topic that appeared in the Hindu paper. So we'll understand about the constitutional provisions relating to the governor and the constitutional provisions relating to the immunity given to the governors, right? And you can understand, and you can you need to understand Article 361 under this article, and you can map this topic under GS paper 2. Now there was a question asked in the year 2019, and what was the question? Discuss the essential features for exercise of the legislative powers by the governor, which means a question on governor can be expected in the UPSC examination. And as the topic of governance keeps on coming in the news, so there's a high chance that the UPSC might ask or can ask a question on governor this year as well, especially on the immunity given to the governors. So let us understand the topic, but before that, let us understand the context. What is the context? The West Bengal of governor has been alleged of sexually harassing an employee of the Raj Bhavan. So woman, she filed a sexual harassment case against the West Bengal governor. Ideally, the governor of the West Bengal should be arrested, right? But as the governor enjoys civil and the criminal immunity, that is protection, he was not arrested. And that's the reason the Supreme Court has said that it is very important to understand and examine the extent of the immunity given to the presidents and the governors. So here we'll understand whether the immunity given to the presidents and governor is justified and what the Supreme Court has to say. Let us first understand the constitutional provisions related to the governor. First, the governor is appointed by the president, right? Second, in order to be a governor, that is the eligibility criteria is that he should be a citizen, he should be at least 35 years old, and he should not hold any office of profit, right? Next, executive functions. The governor appoints the chief minister and other council of ministers and assigns portfolios to them. Legislative functions. The governor has the authority to summon, that is to call, prorogue is to suspend and dissolve the state legislative assembly. The governor also addresses the assembly and outlines, that is explains the government's policy, the state government's policy. Then the governor also presents the annual financial statement, which is the budget, the state budget, before the assembly. Now when no political party has got the majority, then now the governor uses his or her discretionary power to appoint a person as a chief minister in a state. So this is the discretionary power of the governor. Now when it comes to the relation with the union, the governor, who is actually appointed by the president, acts as a link between the central government and the state government. So governor, he is acting as a link. And before occupying the position, the governor is expected to subscribe to an oath or affirmation as prescribed in the third schedule of the Indian Constitution. This third schedule, it deals with oaths and affirmations of prime ministers, ministers, etc. Right? So these are the powers and functions of the governor. Now the term of governor's office is generally 5 years, but president can also be dismissed by the governor can also be dismissed by the president on the advice of council of ministers, which means this is not the discretionary power of the president, which means that the president can only dismiss the governor on the advice of the council of ministers. Without a valid reason, the president cannot dismiss a governor. The president can dismiss a governor only when he feels that the governor has acted against the constitutional interest or against the public interest, if his acts are unconstitutional in nature. The governor can also resign from his position. So, these are the ways of how a governor is removed in our country. Please remember that there is no impeachment process to remove a governor as it is with the president of our country. Now, immunity power of the governor, very important. The question is, why is it that the immunity is granted to the presidents and governors? Students, the reason is that the reason why the immunity is granted to the presidents and governors is to ensure the smooth functioning of the office, which means for the presidents and the governors to work without any fear or without any intimidation or without any pressure. These type of immunities are given to the president and the governor. But given the immunities are misused by the governors, this immunity is now subject to judicial scrutiny and interpretation. What kind of or which kind of immunity are we talking about? Article 361. Article 361 provides immunity to the president and governors. Clause 1. The president or governor, they are not answerable to any courts, which means no court of law in a country can summon the president or a governor. They are not answerable to the courts. This is one of the privileges or immunities given to the president and the governors. Next, no criminal proceeding can be initiated or continued against the president or governor during their term of office. Which means even if a president or governor, let's say, murders a person or rapes a person, he or she cannot be arrested. This is the criminal immunity granted to the president or the governor. You might wonder, why is it that such blanket immunity is given to a president or a governor? Does it also mean that the president or governors have the power to kill and commit any criminal offense? Students, here what it means is that whenever a person is a president or a governor, he or she or a criminal case cannot be filed against a person. Let's say, for example, a governor of a state commits a murder. Now, in such case, first the governor will be dismissed, right? Only once a governor is dismissed, then the criminal action can be taken against the person, because now he is not the governor. So, this is how proceedings are initiated against the president or the governor, right? At the same time, no president or governor can be arrested or sent behind the bars during their term as the constitutional position. Civil proceedings can be initiated, yes, but after giving 2 months notice to the president or the governor. So, these are the immunities granted to a president and governors under Article 361 of the Indian Constitution. I hope students you have understood what is Article 361 of the Indian Constitution. They are not answerable in any court. No criminal file or no criminal case can be filed against the president or governors. They cannot be arrested or imprisoned, and civil proceedings can be initiated, but after giving 2 months notice. Now, let us talk about the issues pertaining to the Article 361. First is the extent of immunity. Now, to what extent the immunity is granted to a president or governors is a question. Does this mean that when a president or governor in their personal capacity, if they misbehave, or let's say if they are involved in any wrongdoing, does it mean that they won't or no action can be taken for their personal misconduct? This is what the Supreme Court is interpreting. As of now, blanket immunity is given to a president or governors. But if in their personal capacity, if they are behaving wrongly, then will this provision apply to a president or governor is what the Supreme Court is interpreting, like in the current example of the West Bengal governor. Now, the second is the judicial interpretation. In the Rameshwar Prasad versus Union of India, it has established that the governor enjoys complete immunity from court proceedings. Yes, the governors, they enjoy protection from court proceedings is what the Supreme Court opined in the Rameshwar Prasad versus Union of India. But this ruling did not extensively cover criminal allegation. Delays in justice. Now, by giving protection to a president or governors, does it mean that we are dealing justice to the victims? By giving protection, actually we are dealing justice to the victims. This is a problem. This is an issue that we need to address. And given that the president or governors are misusing their powers, there is a question onto the extent of immunity that should be granted to a president or governor. Now, this Rameshwar Prasad vs. Union of India case has reinforced the governor's immunity but did not address the criminal proceedings, which means again it's a grey area. In the Babri Masjid demolition case, the Supreme Court allowed fresh charges against leaders but deferred the trial of Governor Kalyan Singh, which means again by the interpretation or judgments of Supreme Court, it can be said that the presidents and the governor, they enjoy immunity. Now, whether this immunity also covers criminal acts is something that the Supreme Court will decide in due course. So, the fact of the matter is, giving blanket immunity or protection to a president or governors is arbitrary. So, what do? We can establish a code of conduct for governors which should be approved by the central and the state government, so that this code of conduct guides the discretionary powers of a president and governors. One. Second, you have to fix the tenure of the governors and the president, which means governors should not be dismissed as per the whims and fancies of the central government. Second. Third, there should be judicial supervision or oversight to cover allegations of personal malafide actions by the governors. So, if a governor of a president is involved in any personal misconduct, then yes, there should be judicial scrutiny and there should be a scope or provision through which appropriate actions can be taken against that president or governor. Clear appointment process. The appointment process has to be clear and transparent. And then certainly we have to amend Article 361 to allow immediate investigation and evidence gathering in cases of serious criminal allegations, as the West Bengal governor is subject to currently, right. So, these are the protections, or these are the provisions of protection or immunity given to a president and the governors. Now, whether or the extent of which or extent to which the immunity is given to a president or governor is something the Supreme Court is interpreting and understanding the subject. I hope students you understood the constitutional provisions relating to a governor and the immunity or protection granted to a president or a governor, right. I hope you understood all the dimensions that we have covered in this topic, most importantly the dimensions relating to the immunity granted to the governors. So, students, that's it on this chapter on immunity granted to a president and governors. So, students, if you want us to continue with such initiative, then please do like, share and subscribe to Narayana IAS. Thank you so much.